So, what happens when a major global power just doesn't have a written constitution? Today, we're diving into the UK's missing rulebook to figure out how a whole nation can work without one. I want you to imagine trying to play a really complex game, but all the rules aren't written down in one place. Kind of confusing, right? Well, that's pretty much the reality for the United Kingdom. While most countries have a single formal document you can actually point to and say, that's the Constitution, the UK, well, it simply doesn't. You see, on one side, you've got what are called codified systems. Think of a country like Namibia, where its constitution is literally called the supreme law, or even China, where the constitution is heavily shaped by the Communist Party. But the UK is different. It's uncodified. Its constitution isn't a single book. It's more like this living thing that has evolved organically over hundreds of years, born from gradual change rather than one big revolutionary moment. That's the big question, isn't it? If you can't just Google the Constitution of the UK and read it from page 1, how on earth does anyone know how the country is supposed to be run? Let's get into it.
Okay, the best way to think of the UK's constitution isn't as a book, but more like a recipe, with a bunch of key ingredients that have been mixed together over a very, very long time.
So here are those core ingredients. First up, you've got statute law. These are the big, important acts of Parliament that really shape the country, things like the Human Rights Act. Then there's common law, which is basically this massive body of principles built up over centuries from judges' decisions in court. Third, and this one is a huge deal, are the constitutional conventions. These are the powerful, unwritten traditions that everyone just accepts as binding, like the idea that the monarch has to act on the advice of their ministers. And finally, you have the royal prerogative. These are the old-school, historic powers once held by the monarch that are now mostly used by the government. Okay, so you've got this unique mix of ingredients. But what actually holds it all together? Well, it's all balanced by 3 fundamental principles that act like the system's DNA.
First, and you could argue this is the most important one, is parliamentary sovereignty. What this means is that in the UK, with no supreme constitutional document to answer to, Parliament has the ultimate legal power. It can make or unmake any law it wants, and, this is key, the courts can't just step in and strike down its laws.
Next up, we have the rule of law. This is the bedrock idea that everyone, and I mean everyone, from the Prime Minister down to the average person on the street, is subject to the law. It's the simple but powerful idea that nobody is above the law.
And our third big principle is the separation of powers. Now, the UK system has this famous overlap, with the government, the executive, also sitting inside Parliament, which is the legislature. But the idea of checks and balances is still absolutely vital. And the judiciary, the courts, are fiercely independent, making sure the government always acts within its legal powers.
But you have to wonder, right? How strong are these unwritten rules really? What actually happens when a massive political crisis comes along and puts this super flexible system under incredible pressure?
This is exactly where theory smacks right into reality. The unbelievably high-stakes legal battles over Brexit gave the UK's constitution the ultimate stress test, and it put all these abstract principles to the test in a very, very real way.
So here's a quick look at how it all went down. After the 2016 referendum, a whole series of constitutional showdowns ended up in the UK's highest court, and they tested the absolute limits of government power and the sovereignty of Parliament itself. The first major battle was known as the Miller I case. The government argued it could use its royal prerogative powers, the power to handle foreign affairs and treaties, to officially kickstart the process of leaving the EU. But was it really that simple?
So, the heart of the conflict was this. The government claimed its historic prerogative powers were enough to get the job done, but the Supreme Court came back and said, not so fast. Their logic was that an act of Parliament had given UK citizens specific legal rights through EU membership. The government couldn't just use a prerogative power to snatch those rights away. That was a job that only Parliament could do.
So, in short, the court totally upheld the principle of parliamentary sovereignty. It ruled that the government couldn't go it alone. It needed a brand new act of Parliament to even start the Brexit process. The unwritten rule book had just flexed its muscles, big time.
But the drama was far from over. Fast forward to 2019, at a moment of just intense political gridlock over Brexit, the Prime Minister advised the Queen to suspend or prorogue Parliament for an unusually long 5 weeks. This move was immediately challenged in court, and that led to the second major case, Miller II/Cherry.
And in a just stunning unanimous decision, the Supreme Court declared that the prorogation was completely unlawful. The court's reasoning was that shutting down Parliament prevented it from doing its core constitutional job, making laws and holding the government to account, and there was absolutely no good justification for it.
The impact of this decision was huge. The judgment wasn't about the politics of Brexit at all. It was about reinforcing two fundamental constitutional principles: parliamentary sovereignty, because, let's face it, Parliament can't be sovereign if it's shut down, and parliamentary accountability, which is the whole idea that the government must be answerable to Parliament. So, at the end of the day, these two massive cases showed us something really important. Even without being written down in one single place, the core principles of the UK Constitution are not just abstract ideas. They have real legal teeth, and they're enforced by an independent judiciary. Which leaves us with one last, really fascinating question. Is the UK's flexible, unwritten constitution a brilliant feature that allows it to adapt and evolve over time? Or is it actually a dangerous bug, leaving fundamental rules wide open to interpretation and political crisis? It's definitely something worth thinking about. Thanks for joining me for this breakdown.